Hi, everyone. My name is Dr. Cadet. I'm the founder of Ascend Occupational Medicine Consulting. Welcome to another episode of Ascend TV. At Ascend, we help self-insured employers lower their workers' compensation costs by providing medical oversight. Over the last few weeks, I have been blessed to participate in several speaking opportunities surrounding this topic of substantial medical evidence. And I wanted to share with you, my self-employer friends, what we are looking for in medical records, not only physicians who are reviewing records, but your defense attorney, applicant attorney, the work comp judges who are making the final determinations on your claim files. What are we looking for in those records that would rise to the level of substantial medical evidence? And what we mean by that is there enough medical detail in the note to prove whether or not the worker had a work-related injury? So a few things that we're looking for is when the doctor is documenting the work injury, things need to be framed in terms of reasonable medical probability. So is it greater than a 50% chance that the complaints the worker is experiencing are due to their job? So a good example would be someone is walking in the warehouse and they stub their toe on a pallet. After stubbing their toe on the pallet, they go immediately to a medical facility because the toe hurts and they get x-rays and the x-rays show a fracture. Is there enough reasonable evidence in that medical record to associate the fracture with the stubbed toe in the pallet? Well, I would argue that yes, the worker had an incident at work. They came soon thereafter to get medical treatment. When they got the medical treatment, the doctor documented that they saw bruising on exam, that they saw tenderness when they pressed on the toe, and then the doctor even obtained objective evidence or proof that something was wrong with the toe because we have an x-ray showing a fracture. If all of those things are detailed in the medical note, then that would cause it to rise to the level of medical evidence. You have enough detail in that note to say, yes, this work injury happened and it is caused by the person's work. So in addition to the medical condition being reasonable, there also needs to be, as I mentioned, documentation of the physical exam and the history. I've come across multiple reports where the doctor documents a diagnosis, let's say medial epicondylitis, which is doctor speak for tennis elbow. So they've documented that the worker has tennis elbow. They've said that tennis elbow is due to the person's job, but they didn't explain what the physical exam findings were. And in the medical community, if you don't document it, it didn't happen. So there was no physical exam. As you go through the history, the worker is not reporting elbow pain. They're actually reporting wrist pain. But for whatever reason, the doctor still gives a diagnosis of tennis elbow in addition to wrist strain. That does not rise to the level of medical evidence required because there was no documentation in the history of how this worker's job led to elbow pain. There's no documentation of a physical examination. So for that reason, that diagnosis would not be considered meeting the standard of medical evidence. The other thing a medical report needs to have in order to rise to the level of medical evidence that we need to see is there needs to be some explanation of the doctor's thought process. What is their reasoning behind what they are saying? So if I explain the worker was walking in the warehouse, they weren't wearing steel-toed boots, they were wearing tennis shoes. When they struck their great toe on the corner of the pallet, experiencing pain, and subsequently had an x-ray that showed a fracture, I believe the toe stub at the workplace caused the fracture because excessive force on the toe on a hard object can cause a fracture. I'm elaborating on my thought process versus when a doctor writes tennis elbow and they're not giving any explanation on how can someone whose primary job is typing, how do they develop tennis elbow, especially when we know tennis elbow is a disorder that's caused by repetitive motion. How does someone who is typing at a desk, moving their hands, but typically when you're typing, you're not moving your elbows, how does one develop tennis elbow from typing? So there needs to be an explanation of the thought process. So other forms of evidence are not only the history, the physical, but any laboratory studies. We've talked about imaging. Sometimes you will have workers who are referred to a specialist, and the specialist is giving opinions on the work injury that the worker has sustained. You can use medical literature. And so in medicine, different types of literature are ranked, right? And the highest level of medical evidence is a randomized controlled trial. And so any type of peer review article will be helpful as you're collecting evidence on an explanation as to why what the worker experienced led to a work injury. Case studies can also be used, even though they are lower on the totem pole in terms of strength of medical evidence. You can also use medical guidelines. So in the occupational medicine community, we use the American College of Occupational and Environmental Medicine. They have medical guidelines that we can also use when we're building a case for why something is or is not work-related. The opinion needs to be based on pertinent facts. And unfortunately, there are instances where a worker will come in and report an injury that was not caused by work. So the providers that are taking care of your employees need to do a very good job of documenting not only what the worker said, but what objective proof do they see on physical exam or imaging that would substantiate that there's been an injury. If there's any type of video recording of the incident. So the gentleman who works in the warehouse, they have cameras all over. Perhaps him stubbing his toe on the pallet was caught on camera. And so if it is caught on camera, that's great. Maybe that individual says that they stubbed their toe on a pallet at work, but it really happened at home. We have video of this individual at work, and there is nothing on camera indicating that he ever stubbed his toe. So if you have video of a person getting hurt at work, that's helpful information that you can send to the doctor for them to review and include in the medical documentation as to why this injury was caused by work. And so if the doctor is not explaining their medical reasoning, it is not sufficient. And I would encourage you to have your adjusters look for that in the medical documentation because it will save you a lot of heartache down the road. In a lot of these conferences that I was speaking at, where I was able to sit alongside work comp judges, they commented on how they would have to send things back to the representing attorneys because what was written in the medical records was not sufficient. So as your adjusters are getting the medical documentation and they're seeing one-liners, they're seeing things that aren't clearly explained, there's nothing wrong with reaching out to the treating provider and asking for them to elaborate on what they've put in the note. A lot of doctors are seeing 30, 40 patients a day, and they're not thinking about the downstream consequences of their brief note. And so sometimes they just need a little bit of a push to say, hey, this is what we need from you in order to make this note rise to the level of evidence that we need as we continue taking the file down the work comp pathway. And so sometimes your claims team may be looking at files and they're not really sure, is what the doctor wrote sufficient enough for our purposes? And so if you've ever come across that type of question, I'd love to invite you to our upcoming webinar. It's going to be this Wednesday at 12 p.m. PST or Pacific Standard Time, and we're going to be talking about the 4 types of claims that no one wants and how to spot them early. And we'll be talking about medical documentation and what your adjusters can be looking for. So if you've not already had an opportunity to register for that, the link is in the show notes, and I hope to see you there. Until next time, peace.